Sometimes a probate case simply slows down.
Weeks pass.
Then months.
And families begin asking the same question.
Is the case actually moving forward?
Or has it quietly stalled?
Stalls can happen for many reasons.
Missing information.
Ongoing negotiations.
Or uncertainty about the next procedural step.
When that happens, families often begin exploring their options.
Not every stalled case requires confrontation.
But it does often require a strategic decision.
Should the case simply continue as it is?
Should someone push for court action?
Or should the overall strategy change? To understand those choices, it helps to look at a simple framework.
The probate strategy map.
A way to visualize the main paths families consider when a case stalls.
In practice, most responses fall into 4 broad categories.
Some people decide to escalate the issue.
Others begin participating more directly in managing the case.
Some decide to continue waiting while negotiations unfold.
And some explore settlement to resolve the dispute.
Each path carries its own risks and costs.
And each can affect how quickly a case begins moving again.
In the next section, we'll examine the escalation path.
And how formal filings can sometimes restore momentum in a stalled probate case. One response families sometimes consider is escalation.
Escalation usually means bringing an issue formally before the court.
This can happen through motions,
Objections,
Or requests for hearings.
These filings place a specific issue before the judge.
And once an issue is formally filed, the court usually must respond.
Sometimes by setting a hearing.
Sometimes by ordering information to be provided.
And sometimes by requiring a response from the other side.
Escalation can bring clarity to a stalled situation.
Because questions are no longer discussed privately between attorneys.
They become part of the court record.
That can sometimes restore momentum in a case.
But escalation also carries costs.
Legal fees may increase.
Positions may become more adversarial.
And disputes may take longer to resolve.
For that reason, escalation is only one possible strategy.
Some families prefer negotiation and settlement.
Others continue waiting while negotiations develop.
And some begin participating more directly in the management of the case.
In the next section, we'll look more closely at settlement strategies.
And how negotiation can sometimes resolve disputes before they reach the courtroom.
Another common path when probate cases begin to stall. Another common response to a stalled case is settlement.
Settlement means resolving the dispute through agreement rather than court rulings.
This often happens through negotiation between attorneys.
Sometimes with the assistance of mediation.
The goal is to find a resolution both sides can accept.
Without requiring the court to decide every issue.
Settlement can reduce uncertainty.
And sometimes reduce legal costs.
Because extended litigation can be expensive.
However, settlement also involves compromise.
Both sides may give up something.
In exchange for closure.
For some families, that trade-off is worthwhile.
Especially when cases have already lasted many months.
Or when legal costs are beginning to rise.
Settlement can also restore momentum.
Because it allows the estate to move toward closure.
Rather than continuing through additional litigation.
But settlement is only one of several strategic choices.
Some families continue waiting for developments.
Others explore hybrid approaches to managing the case.
In the final section, we'll look at those hybrid strategies.
Including situations where people begin participating more directly in their case.
Often while continuing to work with legal counsel.
Another option when probate cases begin to stall. A third response some families consider is a hybrid approach.
This means participating more directly in the management of the case,
sometimes alongside legal counsel,
and sometimes handling specific procedural tasks independently.
for example, organizing evidence,
tracking deadlines,
or preparing drafts of procedural filings.
In some cases, individuals may also file documents themselves.
This is commonly known as appearing pro se,
meaning a person represents themselves in court.
Courts generally allow this in civil matters, including probate.
However, it also carries responsibilities.
Procedural rules must still be followed.
Deadlines still apply.
And filings must still meet court requirements.
For some families, this hybrid approach helps manage legal costs,
while still maintaining professional legal guidance when needed.
Others may decide the risks outweigh the benefits,
which is why the strategy map includes several paths:
escalation,
settlement,
continuing to wait,
or participating more directly in the process.
The appropriate choice depends on the situation.
In the next appendix, we'll explore what self-representation in probate actually involves.